So here we are at the top of page 7, where we have another box that we can check off if the buyer intends to obtain funds from the following other sources. So if there's any other sources that the buyer is going to obtain funds from, we would need to put it in this section here. Okay, in this note, let's see what this box says. It says that the buyer obligation under the contract are not conditioned upon obtaining any other loans or any other funds from sources other than the buyer's own assets. So some mortgage loan programs and other programs providing funds for the purchase of the property selected by the buyer may impose repair obligations and or additional conditions or costs upon seller or buyer, and more information may be needed. Material changes with respect to the funding to the purchase of the property that affect the terms of this contract are material facts, and that they must be disclosed. So this is what this is stating here, that this property does not, the buyer is not obtaining any other loans, and if there's any other type of mortgage loan programs that's out there that we're using, it may require some different information. So we need to go ahead and address that and get the necessary information in, addendums in, forms in, documents in, that we need to attach to this, because that could be considered a material fact, and we need to disclose if we're making any changes to the contract and how we're getting finance. And this portion here is saying that the buyer does or does not have another home to sell or lease that will affect this loan, the completion of this loan. And then if the buyer does, then we need to put that address down here of the location, 124 Main Street, that the buyer owns as well. And then we need to check this box off here, and it's stating that the property is under contract as of the date of this offer, and the copy of the contract has either been previously provided to the seller or accompanies this offer. So if this other home is under contract, then we need to have the offer to purchase, and it is stating here at the bottom that the seller is strongly encouraged to obtain this contract from the buyers on that property and go over it prior to them accepting this offer. And this section here is stating that it does not. The other property is not under contract as of this time. However, it will be actively listed by and marketed by a licensed real estate agent. That it is listed. Actually, it is listed is first. We need to state that if it is actively marketed by a realtor, if it's not yet actively marketed by a realtor, and if the buyer is attempting to sell this home pretty much like as a for sale by owner without a realtor. So let's take a look at this note. This is not conditioned. This contract is not conditioned upon the seller, lease, or closing of the buyer's other property. So what it's saying is that yes, we've had this information on the property. It is under contract or it isn't under contract. However, we know that the buyer has another property that they are going to sell. This statement here is saying that it has nothing to do with the the purchase of this property. At this point, it's not conditioned upon the sale of this property, but the rest of it is saying that if by chance the parties agree to make this contract condition on the sale or lease or closing of the buyer's other property, then the appropriate contingency addendum should be drafted by a licensed North Carolina real estate attorney and added to this contract. So right here, we're under the performance of buyer's financial obligation. And this is just stating here that the buyer is acknowledging that there's no other circumstance that is going to prohibit them from purchasing and moving forward with this actual contract, the contract that we're in now. So moving forward with this transaction, the buyer is stating that there's nothing that's going to hinder that from happening. And then this section here is It's talking about the residential property disclosure. I just kind of said it in a shorter form. It's actually called the Residential Property and Owners Association Disclosure Statement. So you will hear me just say the Residential Property Disclosure. This is what I'm referring to. And this is a disclosure that is signed by the seller during the listing portion, and this one as well. The mineral, oil, and gas rights. Now with the residential property disclosure, as realtors, we do present this to the sellers. We are not able to coach them in any way. They are giving us information and answering all the questions regarding the property on both parts. The mineral, oil, and gas rights, has it been severed, and every question that they have regarding the property, the roofing, the plumbing, how old the roof is, and so on and so forth. They're to answer these questions without our help. If they have questions regarding a certain question as to what it means, we can help them as a realtor, but we're not able to coach them through and walk them through it and sign it. This is their home. They should know about their property, so they're going to fill out everything that they know. And what this statement is saying here is that we're saying that we received this prior to even making an offer. So we need to have these disclosures before we even submit an offer, so that it kind of give you a leg up on what's going on with this property, so you can be a little bit more assured before we even get into the due diligence portion of it. When we get to your inspections, you can have a kind of heads up or get ahead of the game by having this residential property disclosure and mineral, oil, and gas rights before we even submit an offer. So this is what this is saying. We're stating that we did get it, we did not get it, and so on and so forth, and or even this bottom one, that is exempt. Now the only time this residential property disclosure is exempt is if you are purchasing a new construction. And also with the mineral, oil, and gas rights, it pretty much the same rule applies with the residential property disclosure. We need to check off if we got it before we made this offer, if we didn't, if we did, or if we didn't, and then also if it's exempt. Now with the residential property disclosures, this one is exempt if you are purchasing a new construction. However, the mineral, oil, and gas rights, it is still required because we are talking about the land versus more so the property. So we're at the bottom of page 7. And we are looking for those initials. The buyer's receipt of a mineral and oil and gas rights mandatory disclosure statement does not modify or limit the obligations of the sellers under the paragraph 8 of this contract, and shall not constitute the assumption to the approval by the buyer of any severance of the mineral, oil, and gas rights, except as may be assumed or specifically approved by the buyer in writing. So in this note, the parties are advised to consult with a North Carolina attorney prior to signing this contract if severance of mineral, oil, and gas rights has occurred. So this is what this is saying. We need to know if there are mineral, oil, and gas rights. It doesn't exempt the seller from selling this home. This is still a binding contract, but if the mineral, oil, and gas rights have been severed, we need to consult with the attorney regarding this. So here we are at the buyer's responsibilities and obligations. So the buyer's obligations, the responsibility for special assessments. The buyer shall take the title subject to all special assessments that may be approved following the settlement. So this means that if there's any assessment, special assessments that's going to be approved after you purchase the home, this is your responsibility. Okay, so the responsibilities for certain costs. The buyer shall be responsible for all costs with respect to any loan obtained by the buyer, charges by any association or management company, the appraisal, the title search, the title insurance, any fees charged by the closing attorney for preparation of the closing disclosures, seller disclosures, and disclosures, or any other settlement statements, recording the deed, and the preparation and recording of all instruments required to secure. So this is all a part of your closing costs. So this is the stuff that you're responsible for, and this is itemized, and they just want you to know that. So here we are on section C, and this is authorization to disclose information, and it is just stating that you are authorizing to release to the buyers or to any myself as a real estate agent or to anyone that's involved in this contract any information therein to the parties to this transaction, their real estate agent and buyer. So you are disclosing that you are authorizing us to, pass this around to any of the inspectors, the appraisers, or whoever, anything that's in this contract, you are agreeing basically to allow us the other parties to view it. So next up on 7 is the seller representation, and this section is stating how long the seller has owned the property, whether it's owned it for at least a year, for less than a year, or does not yet own the property. The lead-based paint, we need to check that is applicable. So that means if the home was built prior to 1978, we need the lead-based paint or lead-based paint hazardous disclosure addendum that needs to be attached to this too. So that needs to be uploaded to the MLS, the transaction desk, so I can obtain that, so we can go over that with you as the buyer as well to make sure that there's no issues, no hazardous conditions that we are entering into. Hey, let's check out this warning. If a lead-based paint disclosure is required but not given to the buyer prior to seller's acceptance of this offer, the buyer may not be obligated to purchase this property under the contract under the federal law. So that's important. The sellers have an obligation, the seller side, to disclose all of this information to us. We need to have that residential property disclosure, that mineral oil and gas right, and most importantly, this lead-based paint. If that house is built prior to 1978, this is for your safety. So they have to disclose that to you, or you may not be obligated to purchase this property under the law. And this is speaking of the Owners Association dues, the seller authorizes and directs any Owners Association and any management company of the Owners Association, any insurance company, and any attorney who has previously represented the seller to release the buyer, buyer's agent, representative, closing attorney, or lender true and accurate copies of the following items affecting the property, including any amendments. So this is the items that we are looking for: the seller's statement of accounts, the master insurance policy, declaration of restrictive covenants, rules and regulations, the articles of incorporation, the bylaws, and current financial statements and budgets of the Owners Association, the parking restrictions and information, and architectural guidelines. So this is when it comes down to HOAs, we need this information, especially when it pertains to condos. So, and this is the HOA information that will be needed: the name of the company, how much you're paying per month, or if it's per year. So this is, how much you're paying, and then we're going to put that per month or per year, whatever that item is. And that's usually on the MLS as well, to let you know what your HOA dues and fees are as the buyer. Again, got some initials here stating you understand everything that's been said previously.